Joining us now to discuss what's at stake is constitutional law professor James Sample from Hofstra School of Law. Good morning, Professor. Thanks so much for taking some time to talk to us.
Good morning. Thank you.
So, Professor, there are two cases before the court. What are the challengers objecting to here?
Well, in many respects, in our politically polarized era, this is an old school legal battle, high stakes for millions of Americans, complex issues of law, and most notably, principled arguments on both sides. Fundamentally, the Biden administration's position is that Congress, through a 2003 law known as the HEROES Act as part of the post 9/11 era, gave the Secretary of Education expansive authority to reduce student debt in the event of national emergencies. Now, to be clear, the Trump administration relied on that same law for the pause in loan payments, but a pause is different than a $10,000 or $20,000 debt reduction. The challengers, 6 Republican states and 2 individuals, argue that the Biden administration's debt relief amounts to an executive branch overreach. That is to say, the challengers dispute the idea that the HEROES Act applies here and argue that more specific, more explicit authorization from Congress is needed. Thus, this is a classic constitutional law question. It's not a matter of whether the debt relief is good policy and whether debt should be forgiven. The case is about whether the executive branch acted within or beyond the scope of what Congress authorized.
Is there any precedence for this case?
Well, there's a precedent in the sense that there are many cases throughout American history that deal with fundamental separation of powers issues and whether or not the executive branch is acting within the scope of statutory authority. What's interesting here is that if the court reaches the merits of this case, the 6-3 supermajority of the conservatives will likely strike down the plan. That said, there is a compelling argument that the normal ideological divide on the court may be scrambled as to a preliminary question. Do the parties who are challenging this plan have the legal standing to do so? Meaning, are they specifically harmed enough by the program to bring this case? And what is fascinating, Mary, is that traditionally the court's conservatives take a very narrow view of standing, a position that here would favor the Biden administration, and traditionally the court's liberals take a broader view of standing, which here would favor the opponents of debt relief. In other words, not every court case, even in this era of hyper-partisanship, maps perfectly with our ideological divide.
And speaking of the court's conservative majority, how do you think the arguments are going to go here?
I think that if the majority is able to overcome the hurdle of the standing question, I think then the majority of the court will focus in on a doctrine known as the major powers doctrine, and the idea that in order for Congress to authorize a plan of this scale and scope, it needs to do so expressly and explicitly, and that would not bode well for student debt relief.
What happens if the justices strike it down? Does the Biden administration have any other options here?
Not many in the near term. They could try to make minor modifications to the plan, but those too would be subject to yet more court challenges and yet more delays. I think if the Biden administration's plan is struck down, their real option is to make student debt relief and the GOP's opposition to it a campaign issue for 2024.
And when can borrowers expect to learn the court's decision?
I think the court's decision will be released by June, and the Biden administration has stated that no matter what the decision is, the pause on student loan repayments will be lifted as of 60 days after the court's decision, no matter what that decision is.
Hofstra School of Law professor James Sample, thank you for being with us.